issues relating to property transactions, and you know this show is called Property Matters, brought to you by Ascent Realty and supported by Ascent Radio. So today we are here again to discuss another very pertinent issue that concerns property ownership, and our topic for today is property joint ownership. Can a spouse retain a property purchased before marriage? Can a spouse retain a property purchased before marriage? That's what we'll be discussing today. My name is Destiny Unuati Ijibo, and we are going to start by telling a very brief story as we always do. And today we have Mr. Oko Ujo, who is our cast for today's story. He is a very wealthy man and he owns lots of property to settle down in a few months from now, and he has come to meet you because he has heard several stories that upon getting married, in a few months or a few years after getting married, marriage fails. The property that the person who before getting married acquired will be shared between both parties. If it's the wife that acquired those property because the man came in, they are going to share the property. If it's the man that acquired that property amongst them equally, he's now scared. He has made so much money, he has acquired so many properties. How is he now going to share his property with someone who may just get married to him because he has seen that he is wealthy and he doesn't want to go through that route? If there is an escape route for him in order to avoid having his property shared with someone else, just in case the marriage fails, though he doesn't intend to have a failed marriage, but he wants to protect himself just in case it happens in the future, because no one can tell what will happen tomorrow. So that's the basis for our discussion today. Do not say, okay, because I anticipate that I'm going to get married tomorrow, I shouldn't work hard to acquire some property. No. Or because I know the person I'm going to get married to is a wealthy person, I can always rely on the person, therefore I shouldn't work hard. No, that should never be the case. Because you know that a partner that you're anticipating to get married to is a very wealthy person, then you now stop working, stop acquiring your property. No, that should never be the case. Any property that you're acquiring is your own. It could be a part of family property in the near future, depending on what you want. Now, let's quickly look at joint ownership, because we started by saying that property joint ownership. Can a spouse retain a property acquired or purchased before marriage? Now, what is joint ownership? Joint ownership refers to two or more persons having equal or unequal rights to a property. It's possible that two persons own a property, they have 50-50% interest in a property. There are some other circumstances where Mr. A has 20% interest, Mr. B has 20% interest, and Mr. C has 60% interest. It depends on circumstance. Now, when we are not talking about joint ownership, it means there are two or more persons who have interest in that property. It doesn't matter the quantity or the quality of the interest the person has in that property, but what matters is that there are shared interest in the property. We have situations where there is a particular bungalow, but there are several rooms in that bungalow. Mr. A may have 2 rooms, Mr. B has 1 room, and Mr. C having 4 rooms. It all depends on facts. So if this is the case, they all have joint ownership. One person cannot decide to sell the entire building. You must take into cognizance the fact that other persons have rooms in that same property that he intends to sell. Therefore, you must get the consent of other persons before he can proceed to sell that property which they jointly own. That is what joint ownership implies. Now, when we are talking about joint ownership in marriage, it means the parties to the marriage, the man and the wife, they both acquired the property, or the man acquired the property, the woman made certain contribution towards that acquisition. There must be a contribution made by the other party for him or her to claim joint ownership to the property, which may be the subject of litigation at one point in time or the other. Now, can a spouse lay claim to the property that was acquired by the other party before they had or they got married? The position of the law is that when a person acquires a property before getting married, that property remains his personal property or her personal property. For instance, a woman who inherits a property from her father or her mother while she was single cannot now say, okay, because we are now married, the man now lays claim to that particular property. That is not the case. Any property that was gotten before parties came together as man and wife remains personal property of each of those persons. However, where they decide to do otherwise, let's say Mr. A acquired a property and he says, okay, since this is property that I got from here and I want this property to be a family property, he must express that intention. The woman also must express that intention that he or she wants this property to become a family property before it can be property of the marriage. If there is no such express intention by whoever owns the property before marriage, that property remains a personal property of that person. So, on the other hand, if the other person is interested in being a joint owner, he or she must make a positive contribution towards the maintenance of the property. Like I said, maybe they have been married for 5 years and they have lived in that property. At the point of getting married, the property was worth 10 million naira. And after marriage, the man, let's say the property was gotten from the estate of the wife's father upon maybe the partition of the property, or just from the will of the late father of the wife. But the man has been the one maintaining that property for over the period of 5 years. They have done substantial renovation to the property, which was solely financed by the man or financed by both of them. Or let's even say the property was acquired by the man before marriage. The woman, in this circumstance, has been contributing her salary towards the maintenance of the property. Then it becomes a joint property because they have been contributing jointly towards the maintenance of the property over a period of time. Let's say, for instance, as the property was worth 5 million at the point of marriage. Now, because of the maintenance renovation that has been done on the property is now worth over 15 million naira. It therefore means they have shared interest, and the interest that the other party owns there is to the extent of his contribution. Let's say the property is now worth 15 million, and the other party, not the person who inherited the property now, has contributed over 5 million naira in maintenance of the property, and there is evidence to show that that contribution was made. Then there is said to be joint ownership. On the other hand, that the property remains a personal property is when there is no express intention for the property to become a joint property. Now, let's paint a scenario. Mr. A has proposed to Miss B, and they are going to get married in a few months' time. But Mr. A has purchased a property. He has not expressed the opinion that, okay, I am purchasing this property so that I will have a place to live upon getting married, or I'm purchasing this property so that it will become the first property we own as a couple. If that was not expressed before that marriage was contracted, that property remains the personal property of the man. Also, if the man purchased the property without informing the woman, the property remains also the personal property of the man as well. Vice versa also when it comes to the woman. Let's say the woman is the one who has purchased this particular property. He didn't get the permission of the man before purchasing it, or even informing him, and the man did not make any financial contribution towards the purchase of that property. That property remains the property of the woman, even if it was purchased few days to marriage, or even in the marriage as well. As long as there was no express intention by the party that okay, this property is going to be property of the marriage, it will purchase that property in that union. Now, what are circumstances that may lead to a property remaining a personal property or the person that purchased it, even when it is anticipated that they are going to get married? One of the things that needs to be done in order to ensure that that property remains your personal property is to have prenuptial agreement. Now, how does this prenuptial agreement work? It defines the relationship between Mr. A and Ms. B, who are intending couples. Mr. A has 2 houses in Lagos, has another 1 house in Ogun, and 3 in Abuja. But he does not want Ms. B, who he is getting married to in few weeks or in few months, to be a partaker of that particular estate that he has acquired already. Now, what he needs to do is to draft a prenuptial agreement stating that any property that either of the parties has acquired before marriage remains their private properties. It shall not be counted when they are counting the property of the marriage. Let's say Mr. A has acquired the 5 properties that we have listed, and Ms. B also has a share in a company that is multinational, and the shares is worth billions of naira, and they have this agreement. It therefore means each of them retains whatever they owe before getting into that marriage. The prenuptial agreement also defines the contribution that each party is to make in acquiring any property that may be termed family property or property of the marriage. Now, Mr. A has 5 properties, Ms. B has shares that can be converted or let's say sold, and property can be purchased, and they can decide to say, okay, in this prenuptial agreement we are going to contribute 1 million naira to purchase a property. Mr. A, you are to bring 60% of this amount, while Ms. B is to produce the remaining 40% in purchasing this property. And once that property is purchased, it becomes property of the marriage. Whatever they have before purchasing that remains their personal property. They can also decide further that whatever property they are going to acquire while they are married becomes family property. That's what prenuptial agreement does. So it helps you to keep whatever or retain whatever you have acquired before getting married, while also defining the contribution you are going to make in that marriage that you are contracting with the other party. Another thing you can do when it happens that you didn't have any prenuptial agreement is to have any project that you are doing personally financed. How do I mean? If a project is worth 50 million naira and you know you don't have 50 million naira, don't go about sourcing funds from your partner. If you must do that, you must have that a contract that says, I am borrowing this money from you. After a period of time, I'm going to repay you. And you must ensure that you repay according to the terms and conditions that may be agreed upon by both parties. If you fail to get your finances to finance a particular project, a building project in this circumstance that you are engaging in, then the property may be deemed to be a family property or property of the marriage, because your partner has contributed financially, and not just financially, substantially to the purchase of that property. So if you want to be sure that this property remains your own personal property, you must ensure that you finance that project separately and personally. You can decide to obtain a loan from the bank or any other institution to finance that project, and that loan must be obtained in your own name. But if you decide to use the name of your partner because you believe that the name of your partner rings bell at the mention of your partner's name, financial institution or anybody that you approach is likely to give you that loan. If you obtain a loan in the name of your partner, that property can be deemed to be the family property, because the part of the loan that you have obtained in your partner's name was used in financing that project. So your partner can claim that is his contribution, or that is her contribution to that project that you now claim to get. then you must ensure that you repay such loan back if it was obtained in your partner's name. Let's say you approach Bank A and they gave you that loan and use your partner's name to obtain that loan, and you pay that loan. Repaying that loan, you must ensure the checks are given in your own name, but it should be stated clearly there that you are repaying the loan that was obtained in your own name, but the draft should come in your name. If you draw up a draft in your own name, it will always be there that there is an evidence that the money that was used to repay that loan came from your own pocket. On the other hand, if it happens that your partner also obtained a loan to finance a project and the partner is unable to pay, you are the one paying that debt that the partner has incurred, and you raise a draft in your own name as well, that becomes your own contribution to financing that project. If it happens that your partner did not involve you at the initial stage, but by virtue of the fact that you have raised a draft in your own name and you have accepted that debt, it means you have also contributed to the purchase of that property. So anyone who is wanting to have a property that belongs to him or herself alone, then he must ensure that property is financed personally and separately from the other party of that marriage. Then there should be a certainty of purpose. Now, some persons, what they do is they just purchase a property without stating clearly that, okay, this is a personal property, it does not form part of marriage. Let's say there is an investment that was entered into by both parties, the man and the woman. At the end of the day, the investment yielded certain amount of money and it was shared between them. They decided to purchase property separately. That is their own personal investment. But if they decide to purchase a property from that investment, that the profit that they made from that investment, it becomes a property of the marriage. But if that wasn't the case, they invested that money separately, or they purchased two separate properties, and it was clearly stated that property A belongs to Mr. A and property B belongs to Miss B, then there is certainty of purpose there. We are purchasing this property, though it is from the profit of the investment that we made. This property that we are purchasing, this particular one, belongs to the husband, and this other one belongs to the wife. And if that was clearly stated, there is that certainty of purpose, certainty of intention. We are purchasing this property not to be a property of the marriage, but separate properties. Then the property remains the personal property of the person, even if they are already in marriage. Another thing you can also do to protect your interests, if you want the property to be yours and yours alone, is to have documents. Always have documents showing your contribution towards a particular project. If a project was started in your own name and you have been the one financing it, and every record shows that you financed that project, it can always be agreed that that project is yours and yours alone. But if it happens that you only made certain contributions to a particular project, let's say you are alleging that your spouse got this project but you contributed towards this project, you must be able to show that there is something that you contributed, not just by words of mouth. There is a document, like I said earlier, raising a draft. You raise a draft in your own name in order to finance a particular project which your partner has started. If there is nothing like that, there is no way you can prove that that particular project was also financed by you. And also, we have this culture that in our country here, that anything that the woman acquires belongs to the man, because we have this sentiment in our culture that the wife and whatever the wife gets belongs to the man. If as a wife you know that you are from that area where the people hold tenaciously to that particular belief that the wife and whatever she acquires during the pendency of the marriage belongs to the man, you must ensure that you have receipt of whatever you have purchased in your own name. If you are purchasing a house, for instance, a developed property already, you must ensure that you purchase that property in your name, and any transfer, now we have transfer, we do mobile transfer whenever we are going to make payments of any transaction that we have entered into. you must ensure that it comes from your own account. Even if you have saved the money with your husband before now, I want to encourage that get your husband to put that money into your account and pay that money from your own account. And if you have saved the money with your husband and you want to ensure that you don't use it if the money is kept with you, ensure that you keep evidence showing that that particular amount that was paid for that property, you were the one that saved it with your husband. Let's say you are depositing 100,000 naira every week because you run a supermarket, for instance. You are depositing that amount in your husband's account. Keep tellers of transfer or keep records of the dates that those deposits were made. That will help you prove in case of the matter going to court. That will help you to prove that you were the one that actually made those deposits, and that amounted to the current amount that the property was purchased. That is a way you can protect yourself, where you know you have a culture that believes that you and your property belongs to your husband. That's for that. On the other hand, if you want to be a joint owner of a property that was purchased during the pendency of a marriage, you must ensure that you made a contribution to that. We have had several decisions of the court that said that a property, before it can be a joint ownership, there can be a joint ownership on a property, the other party who is alleging to be a joint owner must prove that he made positive contribution towards the acquisition of that property. If it's a project, a building project, you are just developing a property, you are the one who has paid for the cement, there should be receipts that proves that you were the one that actually paid for the cement that was used in developing the property. If your husband has said, okay, you are going to take care of the sand while I take care of the cement and other things, let there be a receipt that shows that you were the one that actually paid for the sand that was used in building that particular property. If it was decided otherwise, that okay, you buy the land while I build the property, there should also be evidence that it was agreed or I paid for that particular plot of land. That is the way you can prove that you made positive contribution in order to claim joint ownership to any property that may be in dispute. Maybe this dispute will only arise where the marriage fails. If the marriage, whether it succeeds or not, you must ensure that you have evidence to your contribution to any project that is being engaged in by your partner, especially when it has to do with property, except you have no interest in that property, whether now or in the future. In conclusion, for a property to be your personal property, it must be clearly stated that this property that I'm purchasing is in my name and I'm the one who has solely financed this particular property. And if it's something that was inherited from either from your parents or